Hi friends, in this video we are going to deal with the case summary of the latest Supreme Court judgment pronounced now in the area of property law, especially matters involving that when a son relinquishes his right to the self-acquired property of the father and the contract is accompanied by the receipt of a consideration, the principle of Estoppel will apply qua the son and his successors. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled ELUMALAI Venkatesan and versus M. KAMALA and others and etc. pronounced on 25th Jan 2023, controversy in this case related to A scheduled property in suit for partition filed by 2 children out of 6 born to appellant's grandfather from his second marriage. The property in dispute was self-acquired property of appellant's grandfather. Regarding the said property, appellant's father executed a release deed. The case of the plaintiffs to exclude appellants was based on the release deed executed by appellant's father. The trial court, however, found that the release deed in question was void for reason that appellant's father executed the release deed in 1975 while his father was alive. It was found that the release deed would not be a bar for appellants to inherit the property of their grandfather. On appeal, the Madras High Court found that the appellants were not entitled to claim any share in the disputed property. Being aggrieved, the present appeals have been filed. The Supreme Court has held that Section 6 of the Transfer of Property Act declares that property of any kind may be transferred except as otherwise provided by the Act or by any other law. Section 6A of the Transfer of Property Act declares that a chance of an heir apparent succeeding to an estate, the chance of a relation obtaining a legacy on the death of the kinsman, or other mere possibility of a like nature cannot be transferred. When appellant's grandfather was alive, appellant's father had at best a successionist. Unlike a co-partner who acquires right to joint family property by his mere birth, no such right exists regarding the separate property of the Hindu. Thus, there can be no doubt that the release deed may not by itself have the effect of a transfer of the rights of appellant's father in favor of either his father or the minor son of his father from the second marriage. The A scheduled property was not the ancestral property of appellant's father, who would have acquired rights over the same only if his father died intestate. He was thus only an heir apparent. Transfer by an heir apparent being mere successionist is ineffective to convey any right. By the mere execution of the release deed, no transfer took place. This is for the simple reason that the appellant's father did not have any right which he could transfer or relinquish. However, if his contract was such that he could be stopped, then the execution of the release deed would imperil his right and therefore cast an irremovable shadow on the claim of the appellants as well, unless this court finds merit in other submissions of the appellants. To repeat, the property in question was found to be the separate property of appellant's grandfather. He married twice. From his first marriage, appellant's father was born and he predeceased his father. Being the children of predeceased son, appellants would ordinarily have inherited the share as decreed by the trial court. The terms of the release deed recite that the appellant's father released his share in respect of the property, and the relinquishment made by appellant's father was based on his receipt of valuable consideration, which persuaded appellant's father to release all his rights in respect of property in question. Conjecturing that appellant's father survived his father and his succession open intestate in regard to the estate of his father, the conduct of executing the release deed, though by itself may not have resulted in a lawful transfer. His conduct being accompanied by the receipt of the consideration would have stopped appellant's father. The very fact that appellant's father did not execute any document by way of will only shows that he proceeded on the basis that the branch represented by appellant's father was being cut off from inheritance from the disputed property. The right which the appellants claim can arise only by treating the property as the separate property within the meaning of Section 8 of the Hindu Succession Act. Therefore, this court is unable to discard the deed of release executed by their father as a covenant within the meaning of Section 8 of the Hindu Minority and Guardianship Act. Under Section 8A of the Hindu Succession Act, property of a male Hindu dying intestate will devolve firstly upon the heir specified in Class 1 of the schedule. The son of a predeceased son is a Class 1 heir. Therefore, it could be argued that since appellant's grandfather died intestate, a right was created in the property in favor of the appellants, being the children of the predeceased son. What Estoppel brings about is preventing a party from setting up the right. The appellant's father, by his contact being estopped, is the fountainhead or the source of the title declared in Section 8A of the Hindu Succession Act. It is, in other words, only based on the relationship between the appellants and their father that the right under Section 8A of the Hindu Succession Act purports to vest the right in the appellants. Further, the appellants would also not be in a position to claim immunity from the operation of the principle of estoppel on the basis of Section 8A of the Hindu Succession Act. The effect of the estoppel cannot be warded off by persons claiming through the person whose conduct has generated the estoppel. Having received valuable consideration and allowed his father to proceed on the basis that he was free to deal with the property without the prospect of being haunted by any claim whatsoever as regards the property by appellant's father, a clear estoppel sprang into existence following the receipt of consideration by appellant's father. Estoppel would shut out in equity any claim otherwise either by appellant's father or the appellants.